In the matter of the Chief Officer, Nagpur Housing and Area Development Board, a MHADA unit versus MANOHAR BURDE, Supreme Court partly allowed the appeal and reduced the compensation payable from rupees 10 lakh to rupees 7 lakh 50,000. It would meet the ends of justice. Respondents launched a group housing project in year 2009. Pursuant to same, petitioner applied for 3 BHK flat and deposited requisite amount of rupees 4 lakh on 23 September 2009, and by virtue of lottery drawn on 3 January 2010, petitioner was allotted a flat. In furtherance of allotment, the petitioner had to pay balance consideration in 8 installments, out of which he deposited 7 installments between 31 December 2011 to 31 March 2013, and the eighth installment was deposited on 26th August 2013 on the assurance that possession of flat will be delivered timely. Prime grievance of the petitioner was twofold. Firstly, the delivery of possession of flat was delayed, and secondly, demand of additional amount posing threat of cancellation of allotment. The said amount was paid by the petitioner, however in vain. It did not yield any result, or possession of the flat was delivered to petitioner. Hence, alleging deficiency in service and unfair trade practice, petitioner filed a complaint. Mr. Tushar Mehta, appearing for respondents, strenuously argued that High Court was not justified in exercising its supervisory jurisdiction under Article 227 of Constitution of India to modify well-reasoned findings of NCDRC, which had balanced the scale by evaluating evidence of parties, including pleadings, and thus allowing writ petition by granting enhanced interest at 15% per annum is not only exorbitant but also contrary to the principles of law enunciated by the court. He also urged that when petitioner had opted for refund of amount at most, the interest was a reasonable rate could have been awarded, as was done by NCDRC. Awarding an interest at 15% per annum on payment made by complainant coupled with additional compensation of 10 lakh is unjustifiable. Hence, he prayed that appeal be allowed and impugned order be set aside. Court stated that NCDRC, having taken note of relevant aspects including factum of delay and fact that petitioner opted for refund of money deposited, rightly held that as a home buyer, petitioner cannot be compelled to take possession of flat after such a long time, and as such ordered for refund of entire amount deposited with interest of 9% per annum, placing reliance on the law laid down by the court in Bangalore Development Authority versus Syndicate Bank, wherein coordinate bench of the court dealing with the question of grant of relief to consumer in cases of delay of delivery of possession held that when possession of the allotted plot, flat, or house is not delivered within specified time, lot is entitled to a refund of amount payable paid with reasonable interest thereon from date of payment till date of refund. The High Court, by impugned order, modified the finding of NCDRC and awarded interest at 15% per annum, primarily relying upon judgment of this court in Rohit Chaudhary and another versus Vipul Limited, wherein the court, in order to balance the equities and to compensate the loss caused to the purchaser or complainant who had booked office premise for his use, directed the refund of amount paid along with interest at 12% per annum from date of the complaint till the date of payment. However, issue in the instant case relates to allotment of 3 BHK flat after payment of sale consideration and delay and delivery of the same. As such, NCDRC, considering entirety of the facts and circumstances of case, awarded interest at 9% per annum, which in the view of the court was fair and reasonable. The interest at 15% per annum awarded by High Court is excessive. Therefore, impugned order is set aside, and order dated 27 July 2022 passed by NCDRC insofar as it relates to award of interest at 9% on the respective deposit till date of actual payment was restored. Court at the time of issuing notice on the appeal noted that appellants had already deposited entire amount with 15% interest including rupees 10 lakh as ordered by SCDRC. Having regard to the fact that appellant herein as an is an instrumentality of the state, the delay, if any, cannot be attributed to personal animosity of officers manning the institutions, and they have been discharging their statutory duties.